Hi, I'm Chris Colvin. I'm the founder of In the House, and welcome to our monthly meeting of our cybersecurity and privacy working group. We always have guest speakers who are experts in various areas related to privacy and/or cybersecurity. And we're delighted today to have Richard Magnan, who's going to speak on the topic of whether lawyers are, in general, tech savvy and knowledgeable enough to serve as cybersecurity stewards, which is an important role that has been emerging in recent years. I think it's fair to say that Richard's answer is, generally speaking, no, and he'll have some suggestions about what we can do about that. But also allow me to introduce my co-host, David Heckler, who's the editor-in-chief of the TAG Cyber Law Journal, and he's been an eminent journalist in the legal field for many, many years. So it's great to have David as a co-host. So David, why don't I pass the torch to you to properly introduce Richard, and then we'll get our discussion going.
Okay, thanks, Chris. Well, we've got someone from a foreign country. I think this is our first international meeting. Richard has actually joined us before. Richard Magnan has joined us before on these meetings, but never as our guest of honor, our expert guest. So I'm going to just say a couple words about him and then let him get started. He has already said he would love to have you all involved in the conversation. I'm going to ask some questions, but we're going to periodically unmute everybody so to encourage you to jump into the conversation. So Richard has had an interesting career. He was a mathematics and computer science major at the University of New Hampshire. So he started as a techie, and then he joined the Air Force and was in Europe and is now in Europe. But he got a master's in computer science, and he started working as an applications programmer for the Air Force. And as he got deeper into that program, he found himself really interested in patents. He started wondering about software patents. And when he communicated this to the Air Force, they saw an opportunity here. They saw that there might be a reason to have someone steeped in both fields. So they offered him an opportunity to go to Georgetown Law Center and get a law degree. And being a wild and crazy guy, he said, okay, I could do that. And he did. And then he was wondering, well, what do I do now? He's still in the Air Force. Am I going to go this way or this way? He wasn't sure. And he found himself in Europe, mostly, doing one and then the other and one and the other. And finally, he came to work at a company called Red Tide, which has two foundations. One, a charitable foundation that does cancer research, and another that's related, educational and other areas. And he slowly became their general counsel. He's the first in-house lawyer, became their general counsel. And then eventually found that they needed someone to oversee the tech world. And he became their chief information security officer, and that's what he's doing now, both. And he has a lot to say about the way not just the two areas communicate, but some of the failures to work effectively together. But I want to start out by asking you, and I'm going to make you the center of attraction here now. I want you to tell us what it was like to find yourself in law school after the background you had, and how some of the different ways that the area is taught kind of threw you for a loop in the very beginning.
Well, thank you, David. I intended to be a mathematician and a computer scientist for my entire career. And so I was happy doing that. But then I went to graduate school about the same time as there were some Supreme Court activity on software patents. And I got interested because I had a friend who was a lawyer in law. He taught me about, he said, well, it's analytical. And I said, no, it's not. He said, yes, it is. He said, believe me. So we talked and we talked. And he said, it's a different type of analysis. But really, the interest came out of self-defense because, as you all know, independent creation is a defense to copyright infringement. You can write the Windows operating system if you've never seen it. That's not copyright infringement. But that's not true for patents. And I was writing a lot of software for the US government. And if I were to write software that were to infringe a patent, the US government could be sued. And so I was concerned about what the lawyers were doing to invade my inherent rights, human rights, as a programmer to write software. I mean, I could understand that if I were to intentionally copy a patent, well, maybe. But if I had never seen a patent and I happen to write software that infringed it, I didn't want the lawyers to be chasing me. And so the Air Force was good enough to send me to law school, and so I began law school with the same approach as I had with mathematics. For every legal issue, there must be an answer. All I have to do is find the way to calculate it. And I kept looking, and this is particularly with legal research, and I just kept looking, and you get close and you get similar fact patterns, but you never find the exact one. And this was a difficult transition. In math, there's always one right answer, maybe different ways to calculate it, but there's a right answer. And in law, sometimes there's one, sometimes there's many, sometimes there's no right answer. You all know from law school that many of the professors say, I don't care what you conclude, I just want to see your analysis. And it took some time for me to realize that in law, I just have to stop looking and accept the uncertainty and conclude that this is the best answer I'm going to find.
Well, you expressed some serious concerns about the way lawyers advise companies on cybersecurity. When you boil it down, what is the gravamen of your concern?
My concern is that they're giving advice at a level, meaning too high of a level, without understanding what's needed by the IT. And let me explain that. Because I sit in the dual position of GC and CIO, I attend a lot of seminars and conferences on both sides. And when I go to my IT colleagues, I ask them, are you getting the support you need from the legal department? And they say, for the most part, 90% or more, no, they're not. They'll ask the IT department for some support, and the IT department will give them a little bit or sometimes nothing. Or if the IT department is concerned enough, they'll give them guidance that's too conservative and you can't use the data. You have to lock it up. But here's where the disconnect comes. I talk to my legal colleagues, in-house or external, and I ask them the same question. They say, yes, we're supporting the IT department. Well, there's a gap there. There's a misunderstanding. And so, what is it? And to me, it's the inability to speak to each other at a common level. I mean, the IT people are not going to be lawyers, and the lawyers are not going to be programmers for the most part. I'm an exception, and I'm still even surprised that I'm both. But that's the problem. There is a gap in the coordination and cooperation of the two career fields when it comes to determining what level of cybersecurity a business needs.
And is it that the lawyers just don't care about? Is it an attitude issue that the lawyers are too busy with their own responsibilities and see this as kind of a nuisance? Or is there something deeper at the bottom of it?
No, I don't think it's at all an attitude. In fact, that's what concerns me. And because I'm not at all being critical of lawyers. What concerns me is they think they've answered it, but they haven't. For example, there was a blog not too long ago put out by a partner at a law firm that says, for cybersecurity, you need to check your firewalls because they could be misconfigured. But then it went on to say, well, but I don't know what a firewall is. And so, and today, if you look at a lot of the blogs, the feeds and such, you can get a list, particularly the post-COVID-19, coming back to work, you need to do this. You need to have encryption, you need to have firewalls, you need to have all this other stuff. And that's all correct, but it's at the wrong level. For example, one of the cases, it was the Yahoo data breach case, they had encryption. And so if the lawyer went to the IT department and said, Yahoo said, do you have encryption? And the IT department says, yes, we have encryption. But they were using an outdated encryption algorithm that had been broken. And so it's not enough to say, do you have encryption? Or it's not enough to say, do you have a firewall? Are they properly configured? Is it the right level? And this is the difference. The lawyers can read a checklist and ask the first level question, but they can't deep enough to see if there really is substance there.
So you've done some teaching now in two universities where you've got lawyers actually learning about technology. And what's your experience been? How intelligent did these lawyers seem to be, and how well did they catch on to what you were trying to inculcate?
Well, they surprised me. I've been teaching for about 6 years now, and I teach an LLM program, so these are all practicing lawyers. And in Europe, I teach here in a master's degree program, which is, here law is an undergraduate degree, and most of them stay for a master's, and then they start practicing. So I'm teaching lawyers who just about finished their studies. They're young, they can use any device you put in front of them. And so I expected them to pick up the technology fairly quickly. And what I try and teach at the first level is just computer architecture. There's a processor, there's central memory, there are I/O devices, and there's a bus or channel between them to show data flow and data storage. As soon as I go into something even high level like that, I'm finding I've lost them. In a class of about 15, maybe 2 or 3 will understand it, but in the LLM, it's joint LLM MBA, and what I end up having is usually a computer scientist as one of the MBA students, and so that's one of the 3. But it's surprising that they don't, and it's, to me, at the high level, it's not that difficult. I'm not trying to teach them the program. I'm not even trying to teach them binary or data representation. I'm just trying to teach them how data flows inside the computer, because you need to know that. You need to know the different ways it stores it. If you're going to validate GDPR software, compliance software, or anything like that, CCPA software.
One thing I want to note is that we actually had an earlier webcast on this subject, because there's an NYU program for mid-career lawyers and others, and technologists, business people at NYU. And it's a master's program in cybersecurity that requires every student to attend classes both at the law school and the engineering school. It's co-hosted by those 2 schools. And for this very reason, they felt that for someone to actually be competent as an advisor in cybersecurity, whatever field they were specifically in, there were only a few. The majority were people in tech, not lawyers. But either one would need training in both. And it's a 12-month program, and they were having success in that. It was a hard thing for the lawyers in particular to grasp, but it was a 1-year program, and they really worked at it, and that was the requirement. So here's the question that we discussed earlier, and there's an article, an interview I did with you that'll be posted on the Cybersecurity and Privacy Working Group resource page, as well as the video we're making now. And we talked about what solutions there might be. Should there be some kind of certification required if a lawyer is holding himself or herself out as a cybersecurity privacy specialist? Should that person need to take some kind of licensing test the way a patent lawyer has to be admitted by the U.S. Patent and Trademark Office?
Well, let me start by saying I'm not a fan of overregulation, so I'm not trying to produce a burden on anyone. What I'm trying to do is to make sure that people really have the proper background to advise, and so maybe something similar to that, where if you're going to practice in front of the PTO, you have to have a degree in the appropriate scientific subject, and then you have to pass an exam. I'm also not a fan of all of these certifications that you can get and you can collect, but there really is not a lot of substance there either. For some, you can take a quick course and you can pass it. So I'm not looking for just amassing credentials. What I'm really looking for is sort of what we're trying to teach, is that the lawyers have to understand that it's not that simple. It's not a checklist. You have to understand something about the technology in order to advise. And so to encourage them to find self-study, online courses, or short courses. We're trying to convert the LLM program into short courses, and I teach a short course at another university, so that you try it. I mean, it takes some effort to learn the basics of how computers work. But once you get past that initial learning hurdle, you will have enough to at least ask the intelligent questions. I mean, I can give you, if you want, a short example of a GDPR issue where
Sure.
I was working with a company. You know, GDPR is a General Data Protection Regulation. I think everybody's familiar with this. It's data privacy. And so as part of that, you have to create a record of processing activity, which is basically what data do you have, what legitimate basis do you have, how do you use it, and where does it sit? So it's basically an inventory of what personal data you have. And I was working with a company that had just switched from their IT support from a local service provider to Microsoft Office 365, cloud-based. Your Outlook is in the cloud, your SharePoint, everything is in the cloud. And so I'm working with one of their representatives, and we're going through the ROPA, and we said, okay, where's your Outlook personal data? And she said, it's in the cloud. I said, yeah, you're right, okay. But you also have to record that it's on your laptop. And she says, no, it's not. It's in the cloud. We moved to the cloud because previous to that, it was local. And I said, well, no, there's a file. It's called a .ost or a .pst file that Outlook has on your laptop with your mailbox. And she says, no, it's all in the cloud. And I said, well, I showed it to her, but I just showed her a file name, and that didn't get me anywhere. And I realized I wasn't getting anywhere. So I said, I tried a different set of reasoning. I said, well, if the data is all in the cloud, you have to be connected to use it, right? Yes. Okay. Can you write emails if you're not connected to the internet? Yes. Can you see your Outlook contacts if you're not connected to the internet? Yes. Well, if you're not connected to the internet and that information is only in the cloud, you can't see it. And now the light comes on. It's also on your local laptop. And so, but she was adamant, and I can understand her perspective. They moved from local, but this is, again, you don't have to know. You don't even have to know that there's an OST or PST file there. You just have to reason through it that say, I know I'm on this airplane, I don't have an internet connection, yet I can do email. Well, and I can see my contacts. So that means there's personal data on your laptop. I mean, I have another one, but I can either save it or let somebody ask a question. But this one is I think even more egregious.
Well, I think maybe we should just stop for a second and unmute people and see if anyone has a question they'd like to ask.
Yeah. Well, if you don't mind, David, I want to follow up on two strands that Richard picked up or mentioned. So two things that really interested me, Richard, in your discussion so far is, number one, this idea that we can make a difference through self-help. We can educate ourselves as lawyers to be more effective, and we eventually can get there. So it's not, what I'm hearing is it's not hopeless. There is education and training that can help lawyers. But I'm also hearing that I have a background as an IP lawyer, as you know, and so and as I think everybody knows, the government has this big infrastructure around IP at the federal level to help companies and individuals innovate and monetize their innovation. So in other words, we have a great government infrastructure sort of on the offensive use of innovation, and not offensive in a bad way, but in using to monetize our intellectual property, right? But we have almost no government infrastructure to protect us against attacks from others in a cybersecurity sense. So there seems to be, at least to my mind, there's a major disconnect between sort of the offensive use of big data, which is pretty strong in our federal system, but almost nothing. And so my question for you is, what do you think we need to do at a higher level, at a governmental level, to equip companies? Or do you think companies are in a position to fight alone to protect their cybersecurity, or do we need more?
I think we need more, and I'll connect back to the session you had with Stuart Baker, and I think that was a very informative session as well. your point about spending a lot of effort to create innovation is right on, because then if you lose it because you don't protect it, then you've wasted all that effort, because the cyber intruders are coming in, and they are, and it could be a competitor, but even probably more likely is China, our nation state, trying to steal the efforts that we have developed. I mean, the innovations that we've developed. And then to go to your question, well, yeah, companies need to do the basic protections. There's room for a lot of cyber lawyers to go out to the companies and make sure you have at least the basic protections there. Now, there's nothing foolproof, and if a nation state wants to get in, they'll probably get in. But then it goes to the other dimension of cybersecurity, is a lot of the intruders are offshore, and it's very difficult. I did it in a previous position where I was chasing internet crime, people doing internet crime. You can do it. It takes a lot of time as a private industry. I even worked with FBI and assistant U.S. attorneys. We had an actual sting operation like you see on TV, an informant who was microphoned, and he met with a top pirate at the time, or doing this piracy. And we ended up having 3 people go to jail, 1 for a year and a half and 2 for 6 months. It took a lot of effort. But that was only possible because of the government assistance. And it's the same thing. The internet is international. And so you've got cross-border jurisdiction. How do you prosecute? For example, Target. Target was breached. They were breached. The attribution was to hackers in Russia. Target paid, I think, hundreds of millions of dollars to the damages to the people whose data that was lost. But Target itself was a victim. And so how does Target recover being itself a victim? It can't sue in Russia. It can't chase across border. And this is where I believe the government needs to come in. The government agencies, there are cases, and I think Target was one, Coca-Cola another, where they didn't even know they'd been breached until the government told them they'd been breached. Now, how do you know? Well, we don't have the data from the government. It's probably what we call traffic analysis, where they saw a lot of traffic going either between China and Coca-Cola. This is a drink deal, orange juice company deal, or between Russia and Target. And so from this traffic analysis, even if you don't know the content, you can see that something's not right. And so they inform the company. So if we could bring together this collaboration where we share indications and warnings and we work together, because otherwise a company can't go cross borders very easily and get damages from the ultimate intruder.
So we have everybody muted again. Let's unmute them and just see if anybody would like to ask a question. You can again do so in the chat window, but I think I see Victor Lee.
Yep. And actually, I did unmute all, but people remuted themselves, which is good etiquette. But Victor, there you go.
Okay. All right. Thanks, Chris. Thanks, David. Richard, very interesting. I have 2 questions for you. Number one, from the GC's seat, there's a lot of functional areas where stuff could go wrong, right? HR, finance, all these sorts of things, right? So are you saying that cybersecurity is different than those in terms of the amount of knowledge you have? Or are you saying that lawyers know less about IT, even at some very basic literacy kind of level, right? So that's kind of question number one. Question number 2 is, because you wear both hats as GC and CIO, how do you deal with situations where essentially those 2 interests conflict, where the CIO would be saying we need to do it this way, for all these technical reasons, and the GC would normally be saying no, yes, but there's all these other legal considerations.
Okay, the first question is it's we have all experienced, as you talked about HR and some of the other things. We've all experienced that as part of our careers. We know what an HR department is. We know how they handle our records and things like this. So, and we've been employees. That doesn't make us qualified to practice employment law, but at least we have some firsthand knowledge. So when we have to go self-educate or take a course, we've got something to base it on. And this goes back to David's, with computer science, this goes back to David's comment, and where being a user, being able to use any device that's in front of you is not the same as understanding how it works. And my concern is that knowing how to use it is not enough to give advice on data privacy, data protection, because you have to know where that data is inside the device. And so you have to understand how data flows, how it may be used. One of the concerns right now is, in particularly for lawyers, a lot of stuff is being done in the cloud. And so if you're using cloud technology provided by your IT department, your company knows about it, you know the data flow, and your lawyers have had a chance to use it. But if your people are using what we call bring your own cloud, meaning they're using a cloud service, a Dropbox or whatever, and they're putting corporate data out there, well, you don't have that under contract. You don't have anything to control that. Your compliance department's not looking at that. And so that's potentially a data breach. And so it's a circumvention of your corporate governance. So in that case, your lawyers don't even have a chance to look at it. But your lawyers won't know that it's being done unless they understand that these services are available. If they simply look at an employee and say he's using Dropbox and assume, well, that must be sanctioned by the IT department, that's not good. The lawyers have to ask the questions. And so this is where it gets to be where the lawyers are not either not comfortable or not induced enough to ask these questions. You cannot leave it to the IT department. The IT department provides services, and they provide services that other people request. So they don't necessarily check that it does everything that they've been asked to do. And so if it's GDPR and it's a mailing list, they may check, does it have a database of mailing list, but the need to know and the access control and the use control may not be in there. That's somebody that understands GDPR that has to go in and test the software. Will your lawyers sit down and actually use the software? Will they ask for a test account and say, okay, IT or somebody from the business, I'm going to use this and I'm going to know myself that it enforces the GDPR. And so unless you do that hands-on, you don't know. Now, the second part of your question, I forgot as I answered the first part. Remind me of
the conflict between your
the conflict. Okay, and that's an excellent question, because this is why I think the two have to be together. You can have this conflict between legal and a business unit anywhere in business, and this is my argument. Cyber risks are no different than any other business risk, and they should be handled the same. The business unit comes in and says, I believe I can make this payment in this country and overseas, and it's not a bribery or anything like that. We believe that this is the cost of doing, or the standard of doing business. And legal comes in and says, no, not at all. And so, okay, you want to start the new business over there? This becomes an internal discussion between legal, the business unit, and the corporate management, board of directors. Somebody inside the company is going to make a business decision, sometimes listening to the legal department, sometimes listening to the business department. But it's no different when it's a business unit or it's it's the IT department. It's the same process. But when it's presented to the business decision maker, when it's a question of potential bribery, they understand that. That's easy to understand. When it's a question of data moving inside of a computer, is it in the UK or is it in the US, or is it properly controlled internal access? Is it a third-party vendor that we're giving control or access to our systems? That becomes a more difficult decision for the business maker unless somebody translates the technology into business considerations. And I'm guilty as charged, but the technicians are not going to do that. I mean, if you can find an IT person who will do it, you're lucky. But I know from being one, I speak technology, I don't speak anything. Your lawyers are more likely to be able to understand the technology and translate this risk to something that the business leaders can understand. And this is why the gap, in my perspective, is even more costly, because the IT people generally are not going to do that.
But have you ever found yourself in a situation, I think this is what Victor was really curious about, where your role as the chief information officer or chief or CISO and your role as a lawyer kind of created a quandary? You could see that there was a disagreement when you put on your one hat, and then when you took it off and put on your other hat, or is it not really a, do you feel like the conflict is most often based on misunderstandings or lack of training?
I cannot come up with a clear conflict between legal and technology, because I am generally very conservative. And so what I will generally do is give you a very conservative legal opinion or a very conservative technical opinion, and then negotiate downward from there. Either whether it's saying business, you shouldn't do this because these are the risks, and then talking to the business leaders and saying, okay, here are your risks. Let's find some mitigation. Let's find a solution, because I don't like to be the no person. I really don't like that. To me, if I have to say, no, you can't do what you asked to do, I believe that I have to give you a way to do it, to do something in a different way. And so I'm always looking for a compromise, whether it's a legal issue or a technical issue, to find a way to say yes to the business. If you do this and this, it's not as good as my ultra conservative solution, but I'm satisfied with it, I'm happy with it, and I think we have a balance in the room. And so I've not yet found a situation in either case where we couldn't find a good compromise to balance the risks, to mitigate some of the risks.
So can I ask a question, Richard? It relates to your career, and it's not unique, but it's unusual in the sense that you're a general counsel with deep technical training. Would you advocate for more companies to think about, I guess, as technological issues come to the fore in many different industries, would you advocate that companies look more for GCs who do have your kind of background, or perhaps send existing GCs back to school to get the kind of training they might need so that they share your background? Is that something you think would be a good strategic move for a lot of companies?
I think it would be good for companies and for all of our lawyers. I mean, digital transformation is happening. Digital transformation is the replacement of people with computers. And it's not just workplace, but it's in the front lines where you in a bank or financial advisory service, for example, in the background they use the computers to do the analysis, but you always met with a client. And that's what digital transformation is getting away with. You're not going to have a human in between you and the business. And so even as your role as a GC in any company right now, you have to understand more and more technology. The companies are becoming more and more automated. And then you've got crises coming out, and I'll just take a slight divergence, but we've got 2 737s from a company that I used to work with in software development, which was excellent. And they both flew themselves well into the ground, according to the press. We've got self-driving vehicles that ran over people. Well, how could this happen? How can this software get out there? And so the legal and compliance department has to take an active role. And whether it's just business, it's not even cybersecurity, it's just the use of computers to do business. Lawyers have to understand the consequences of that, and they have to sometimes get in and say, well, wait a minute, how well did you test it? Are you sure? I mean, is this the right time to let the software take control, or do you need to have a human there overriding it and such like this? And so regardless of whether you're purely an in-house lawyer, you're an external lawyer, or you're a cybersecurity lawyer, technology is growing and growing and growing. And just to be a user, this is the misunderstanding I think a lot of people have. I can use a computer, therefore I know how it works, and I can advise on how it works. You can't. You simply can't. So they have to.
It
I want to ask
yeah,
a question
go ahead.
about cybersecurity versus privacy, because we all know, I think, that Europe has been much more concerned about privacy issues and its regulations have shown that for a long time versus the United States, and GDPR has led the way. So what I wanted to ask you is whether there are differences in attitudes there about cybersecurity versus the United States. That's been less highlighted, different attitudes between the two regions about cybersecurity.
Okay, yes. In the courses, and this is my impression from being over here, but this is also from the courses. When I teach cybersecurity I often teach data privacy, data protection. Either I teach that course, or I teach it with a professor from the university who's teaching the data privacy portion, GDPR and the directive that was before. But I sit in on the classes, and so what they teach is that here in Europe, the protection of personal data is much more an issue than in the United States. But they also balance it out by teaching about the First Amendment rights, the freedom of speech, the freedom of the press, and they balance it out. And so they try to not justify it, but explain it by saying, okay, in Europe, it's very important for people to have privacy, but in the United States, because of the constitutional issues, it's a bit different. And so, in general, the Europeans are more concerned about data privacy and protecting their own personal data. But at a corporate level, the corporations are less interested in protecting against cyber intrusions. And I get this from the external law firms and the big four that I talk to here. Their requests for cybersecurity assistance from a legal perspective are far fewer than they would expect. And this is despite the fact that in general, the population wants their data protected. And I don't have an explanation for this other than the companies here seem to think that cyber intrusions are normal, and that's just the cost of doing business. You lose some data, but also they don't have the large class action lawsuits like we have in the United States, the shareholder derivative lawsuits, and so the litigation that follows a breach here in general is much less than it is in the United States, so the damages are much less. But I think that's probably going to change because more and more data is being lost, and then as GDPR becomes more active, the companies are going to get fined from the regulators, and then the people are going to say, okay, that's nice. You who lost my data paid the regulator, but what about me? And so I think it will grow, but it's growing far slower than I expected, and it depends on the country in Europe too. I've talked with some Swiss data cybersecurity entities who say they have more business from Germany than they do from Switzerland.
Ray Thomas has a question. Ray, you have to unmute yourself, but.
Thank you very much, David. I'm dialing in by phone. I just want to make sure everybody can hear me.
We can hear you.
Yep.
Okay, thank you. First and foremost, Chris, thanks for your prompt response to my email, sending me the invite for this timely discussion. Richard, very good information, and the discussion is so timely for me that it's scary, and I'll tell you why really quickly. I currently serve as IBM's Chief Procurement Privacy Officer, and back in November of last year, I approached a gentleman, one of my colleagues, who runs the Global University Program, and the conversation with him was me presenting to him that he needed to create a special program for law schools, and of course allow for me to run it so that we can close this gap that you mentioned. And I just accepted the offer on Monday. And so my question for you is, I'm curious to know how receptive have law schools and law students been to these types of discussions, because this is exactly what I'll be proposing now.
They've been receptive. I teach at two law schools. One is the University of Fribourg Law School, and the other one is the University of St. Gallen. And Fribourg was first. And the way it happened is I went there for my LLM. I knew the academic director really well, and he knew my background. And he said we need to start this. In fact, we were the first to do this. And the students have been very, very receptive. The class is full each of the 6 years that I'm doing it. We're looking at ways to branch out because the students are interested in it. Cybersecurity is a popular topic. It's before the virus, it was filling the blogs and the news feeds, and the more junior lawyers realize that this is the future. Computers are the future, and you have to know something more than just how to use them if you're going to do anything in business. They're going to be there, and so the enthusiasm is great. I always have some students who are there just to sit there and like an class to try and get credit in an easy way. Well, they don't pass. But those who are interested are very interested, and it's just a challenge of how quickly they can assimilate the computer science language so that I can take them beyond the basics, because I've gone to different levels and into some levels even to teaching binary and just to showing circuits, show how AND gates and OR gates work, just so that you understand that inside the machine everything is a number. And so it's easy to encrypt, it's easy to decrypt. And I show them the flow from a keyboard to the memory to monitor and explain why there's a delay. But in the process, I show them how a keystroke monitor, a keystroke logger works, to show them this is easy. And to show them what I'm telling them, what I often start the course with is tell them, it doesn't, anything you put on a computer can be detected. It can be recorded. Every keystroke, every mouse move, everything that you put there. Everything that you put on the internet, you should assume it's gone forever. You will never get control of that information again. And this surprises them. But this is the nature of a computer. There is no magic. Artificial intelligence is artificial and it's not intelligence. Everything that happens inside of a computer is predictable because some human programmed it to do that. I used to do that. And so it's not a magic box. It's very predictable and it's very repeatable. And if you put something in there, it's captured and it can be recorded forever. And so there is a need, there's a reception. It's just the challenge of getting somebody who's got purely a liberal arts background to understand the technology.
Absolutely. Thank you very much. Two quick comments, and then I'll pass the mic. Richard, I'd love to, take it offline and see if there's some ways for us to, to partner up here, and anybody else on the call who may have some ideas with regard to this new challenge that I've taken on. Lastly, you mentioned the target breach. Like Chris and yourself, I also have an IT background on the soft side, trademarks. And what a lot of people don't mention about the target breach is the damage to the brand, the losses that they took there. You can't even measure it, and I'll leave it at that. But thank you, Richard. Thank you.
Yeah.
Thanks for your question.
Who wants to connect, we can do that. I mean, just a suggestion, and I shouldn't surprise Chris and David, but if you want to have a follow-up session where we just talk about these issues, talk about some of the technology, talk about some of your experiences, I'd be happy to do that, because I'm not at all trying to create an exclusive club of computer scientist lawyers. It's just the opposite. I'm trying to share the information and share the knowledge and the understanding that you have to go beyond the basics in order to provide a good service, and that you can do that. You really can. And it requires a little bit of effort, but it's worth it.
That's probably the best place to end that I could think of. The exchanges, and we're out of time. It so happens.
Yeah, we are out of time.
Perfect way to end, I think, Rick. Thank you very much. Thank you all for joining us. Chris?
Yeah, well, thanks. I don't need the last word. I just want to thank Richard and David for leading an excellent discussion. It's such an important topic, and those of us who somehow ended up with both technical and legal degrees, feel your pain and appreciate you starting to think about how can we solve this big problem. And I really, the two things that just really resonated with me was the need for self-help and the need for government help. And cyber is such a huge issue that we need both, in my opinion. And it's great to know that there's a group of people that feel that way as well. So thanks again. And anybody who has questions about In the House can just go to www.inthehouse.org. And I hope to see you all next month at our monthly cybersecurity and privacy meeting group. And we also have a meeting each Friday at noon Eastern time, which we call GC Casual Friday. So you all are welcome to join us for that as well. Thanks again, Richard. Thanks, David.
My pleasure. Thank you all. We will be posting this video and the article that sort of preceded it within a few days on our resource page.
Yep, and we have all the prior broadcasts too as well on the resources page at inthehouse.org. Thanks, everybody.
Thanks.
Thank you.
So Chris and Richard were